Well, I've been given the high sign, so it's ready to go. I'm Ron Brakke, and I come to you today from the great tundra in the north, the frozen ground of North Dakota. And I'm trying to warm up your spirits a little bit. We got a topic today that needs to be clarified. It has to do with the word trust. And I've said in many presentations I've made, you got to go take a look at a good mirror so that you're sure you know who it is you can trust. And that's terribly important, because your affairs are your business, they're nobody else's business. And a lot of people are having difficulty with their affairs. There is an utopia out there if you can achieve it. The utopia is to create and structure something that would take you personally out of the commerce and use something else that's extremely lawful for you to use, regardless of the scenario you're in. One of the things that's gone on across the country is there's been a lot of people, and I'll use the word quote, selling trusts. A lot of these instruments and these so-called trusts leave much to be desired. They're not, in most cases, not all, but not in most cases, are those vehicles capable of doing what is necessary. I have ran across various trusts in various parts of the country, and to name a few that I'm talking about here so that it'll catch your attention more than anything. There are people selling constitutional trusts, peer trusts, common law trusts, unincorporated business associations, asset protection trusts, business trusts. Legitimate Massachusetts business trust is one of them used, family trusts, offshore trusts, and the list goes on. But the bottom line is you need your feet standing on a foundation in order to make full use of what you've done or what you intend to do. Because it is so important that you know and understand trusts and the flexibility of trusts. Also, I can tell you that I'm not here in front of you tonight to sell you any type of trust. As a matter of fact, those which have worked the best, that I have seen work the best, are given away. They're given to those that are in need, free of any fees, charges, or anything of the sort, because it eliminates a lot of the wrong direction. If you want to start pouring that cement under your feet, the first thing you want to go to is to a law dictionary. And this one here is Black's Law Dictionary, and look up the word trust. It covers several pages in the law dictionary. But you need to know a right of property, real and personal, held by one party for the benefit of another. That's kind of the key words right there. But how in the world is it done? I have seen over the years, and by the way, my knowledge in this started in 1962, which is, a few years ago. And I really didn't get into the nitty-gritty of it, the fact of doing it, until 1985. And it was important at that particular point in time that I decided to grab on and do, because I could start to see what was coming down the road. There's been a constant encroachment on the laboring man's rights in this country, the producer's rights in this country. And the taxation level of it gets to finally they can't exist. Finally they can't pay the debt that they're on the hook for in these 20 and 30-year obligations. And so something needs to be done. There are other things that can pick up the payments on debt and so forth, but you gotta know basically what you're doing. As of this date, as I sit here before you, I can tell you that I've never seen a trust prepared by an attorney yet that was worth the paper it was written on. They're all wills in disguise and predominantly take effect after death. Well, you can do that with just sitting down and writing a one-page will yourself. The job here is to go farther than that, so that the decision, the taxation, doesn't apply at that point in time. That it never applies is the ultimate goal. And it goes along the lines of what the rich and the powerful have done in this country. In 1962, on NBC, the Today Show, I had that on one morning while I was having breakfast out there on the farm, and there was a fella on there that whose name was Norman F. Dacey, and he was telling about the research he had done on how the well-to-do in North America were handling their affairs. And this was basically his recommendation, and a picture of him was right on the back of his book. This, for all practical purposes, for those of us that aren't extremely rich, this basically is the Bible for the handling of the various problem sequences, and including even various forms, so that one can manage the estate, manage the assets. That's terribly important, and once you get into managing it, you develop a sixth sense, and that sixth sense helps considerably. One of the things that people need to do if they're going to plan their affairs, and by the way, I've seen people whose affairs were planned very, very late in their existence, in that they were flat in the middle of bankruptcy even, and create and plan their estate. You can do that and do that lawfully if your will is in it. Otherwise, you're in danger. You're in danger of breaking the bankruptcy code in which you have agreed with your signature to uphold. And so that's terribly important that you look at that even that far. I've even seen families create their folks' estate. You hear me? Their folks' estate several days after they had passed on to the hereafter. But that requires agreement of all of the perceived heirs. It can be done then. The organization can be handled, because you've got agreement then of the beneficiaries, and so they can create it along the lines that they agree to, and they will of course all benefit equally and fairly from it. But also it can keep an organization together. That's terribly important, that you don't disrupt a business enterprise if there's one going on by death. That gets to be a mess that ends up with people who don't know how to handle it. It'll end up in probate court, and there'll be a group of lawyers there sucking off of that trough along with the probate court itself. And of course, a lot of these affairs should not be made public, but in that type of scenario, it is. Now, if already, once you hear this this video or this DVD, have an estate, you, as long as you are alive, are capable of making changes. You can adjust it into something that is more acceptable in the system that has been standing a lot longer over the period of time. And so you don't discontinue or don't scrap what you've already done. You modify it and make the changes so that you have something that's defendable, that's commonly recognized, that isn't a scam. One of the things that a person can do there is start out with the basics of what you need to do. Right here, I have here a stack of documents that represent a Massachusetts formed inter vivos trust, which is basically what Mr. Norman F. Dacey is talking about. This was modified, however. It was modified so that it would fit what I needed. See, I'd seen back here in the 80s when the financial institutions and the courts and law enforcement officials were just stealing farm after farm after farm. And something had to be done about it. And I also got to see what happened to some others. And I can tell you right now that if you're going to create something beneficial to you, to take yourself out of the commerce, to see to it that those that are going to survive you acquire a certain level of knowledge to handle the estate once you expire or your wife expires. It's terribly important that you have continuity. And of course, that's all done through a correct structure. I can also tell you that a good trust is not always what it does say, although much of the time it's the way in which it's structured that's so important. But it's not always what it doesn't say, does say, but what it doesn't say. I hope I didn't confuse you there. Because you can't limit the flexibility of those trustees, or shall I say co-trustees, when it comes to outmaneuvering organized crime. Because you've got to remain flexible, because they certainly target. And it's like putting the cattle in a corral and locking the gate. You've got to be sure that when you go through the trust setup, that there's a way in which you can maneuver and unhook that gate and let the cattle go to pasture. And so, I'm just telling you, a good trust structure leaves with the ability to maneuver, and maneuver lawfully and correctly. What we're going to try to do here is to go from the beginning. And let's take those of you first that do not have a trust organization now. every day is a good day to plan one's estate. And I have seen this interest so vast across the country. But I have a one-sheet document here. One sheet. And this basically, ladies and gentlemen, is going to be the information required to do one, and to do one correctly. Name and address of the trust. And one of the best names to use is a business name. Now, there are those that would like to put their own names into their trust. Well, right off the surface, it doesn't show. It does not show a separation. And so it's like a dog and pony show. You want to be sure. It's the company. You're you, and it's the company. It's terribly important. So good name and address. Name and address of each co-trustee. So you see, you need to get that down on a sheet of paper. Name and address of each co-trustee. Now, you can be a co-trustee too. You just can't be a trustee. You can be a co-trustee. And everyone else be a co-trustee. That's your immediate family, so husband and wife, and also the perceived heirs, the children, can be co-trustees. Keep it within the family, because if you question what you got to do, you got to be sure you take out that mirror and take a look. Who can you trust? You and your wife, the heirs or the perceived heirs. Whatever you have at your departure, you certainly want them to have. That's kind of one of the reasons for doing this, is to see to it it's organized so that at death they may throw dirt on you, but the banking continues, the business continues, the estate continues. You know, there's taxes to pay on real estate, that type of thing. There's improvements got to be made. And you just basically can't stop the world because a person died, so you got to have it structured so that it can continue. And by order of dissension as to who you want to survive, those who create the trust. Now, many people are acquainted with corporations, LLCs, things of that nature. Those are creations of the state. Those can be canceled at the state for any time, at any time. I just saw one this week, certificate from the Secretary of State, canceling a corporation. So, the corporation had been abandoned some time ago. And the name continues, but it continues as an estate. Kind of important that not even the state can destroy your estate. Those state-created organizations are subject to state canceling at any time. Those things which you create are not subject to cancellation. I can tell you this, that I've seen a husband and a wife who created their estate, didn't trust what they were doing, so they made it revocable. Excuse me. They made it revocable, and they went and filed the trust agreement in a court proceeding. Judge read it and said, "I order you to revoke the trust." And they said, no, they weren't going to do that. They weren't going to do that. So they had the sheriff usher them all the way to the jail cell. And just as they were being pushed into the jail cell, they decided that they would revoke the trust rather than be found in contempt. So you don't ever want a revocable estate. Because by revoking it and transferring assets that were transferred to it back, that's a taxable transfer. And I've seen people hooked because the IRS officials, who are usually dumber than a rock when it comes to estates, have convinced them that what they had was no good. Well, I looked at it too, and it was one of the few times the IRS was right, it was worthless. But rather than transfer assets out of it back to themselves, which made a taxable transfer, they should have fixed what was wrong with what they had. But they hadn't looked close, and so they made the transfer back. Then the IRS came in and taxed the transfer back. And of course that hit them in the pocketbook. But then they created a correct estate and transferred in for estate planning purposes. It's terribly important, ladies and gentlemen. You can tell the difference between a legitimate action and a non-legitimate action a lot of times because of whether or not there's a will in it or not. Make sure there's a will in it. For each of you that are creating a trust agreement. Reason for that is because any day you live, you can create your estate with the will in it. You have that right even in the heat of bankruptcy. And that's about as low as you can go, is the heat of bankruptcy. But you certainly can. Also, now that we got a list of all the co-trustees, and it's terribly important they be co-trustees, because if you got a dictator in it, that's who's targeted. There can be a managing co-trustee, but there's nothing that says that. But there can be managing co-trustee. But it requires the decision of all of the co-trustees, if need be, as long as they are listed. There are other properties that people have that need to be looked at as far as description is concerned. If there's real estate that you feel needs to be transferred into the estate, there's grant deed, quit claim. That's basically what a grant deed is anyway. It's just we use the term grant deed and get it from yourself, whatever right, title, and interest you have in that property, transfer that to the estate. And also, when you do that, a good trust will have a homestead declaration in it, so that as the head of the household, you are transferring that to the estate to take advantage of homestead protections as well as reduced tax obligations. That's kind of important on real estate. So you got to get your real estate written down, legal and correct description. And then there's large tangible objects that move, you know, like cars, trucks, boats, planes, you name it. Draw the list of the major items, you know. And later on we'll talk about liability of those. You try to put the items in your estate that are of the least risk. Rolling stock, as long as you keep liability coverage on it, it's probably relatively safe. But the bottom line is you can carry some things that are extremely high liability items. You can carry them in your own name. Because once you have done away with, transferred real estate, transferred major pieces of rolling stock, and transferred bank accounts, life insurance policies, stocks, bonds, and so forth into the estate, you don't want to bring things in there unless they're very successful and a very low risk after that. So, and that's terribly important. And of course, those lists of those vehicles, lists of those bank accounts, life insurance policies, and so forth need to be basically laid down in item 5 here. And also the name and address of children under the age of 18. Well, then you basically have the business affairs roughed out that need something done with it. And that's terribly important, and I'm going to go through some of the documents here. People have a right to create, plain and simple. And the first document of a trust is what is called a trust registration. Once this has been prepared and executed by a co-trustee and notarized or jurated, that is the creation instrument of the trust. And if you're going to open a trust bank account or something of that nature, you're very likely going to need to produce the trust registration. That's kind of important. So that's basically document number 1. That is the created instrument right there. That creates it just like the Secretary of State would create a corporation. You have just created a person under the law that's capable of going out there and doing business. Now, there are trust agreements. This is the terms and conditions, and I'm telling you, and you don't have to listen to me, but I'm telling you that the estate should be irrevocable in nature. Why? Because you can structure it so that it benefits you while you're living. That's important, you know. That's terribly important. But I also want to tell you, if there's 2 of you that are principals in your family to the estate you now have now, his and her trust agreements, they're basically identical with the names and so forth changed. Now I know that people have trouble filling out forms, so I want you to know that about almost 4 years ago now, as I recall, anyway, I made a video on exactly how you fill out each line in all of the documents. So don't get too uptight about worrying about whether you'll know how or not, because I covered each blank spot. And so the trust forms are kind of important, and of course the trust agreements are signed by the trustors. And so you're a trustor and your wife's a trustor, or vice versa. And I've even seen trusts where there is a brother or a sister that has assets single and so on and so forth, who has actually participated directly in with their trust agreement under the same name. So basically what you have here is, for a husband and a wife, you've got 2 trusts operating off of the same name. If there's another member of the family, it's a brother or sister that because of the close working relationship you have and have had all your life, that needs in, then there will be 3. His estate too in it. Now, there are those that are co-trustees that need to sign on to witnessing the fact that you have executed the trust agreement. Also, the responsibilities of a co-trustee also need to be executed. So each perceived co-trustee needs to sign both parts of those, both witnessing your signature and accepting responsibility to conduct themselves pursuant to the agreement. And that's, I always say, important, because within that is the learning. Now, here's what is called a grant deed. You know, that needs to have the legal description of property in it, and the party of the first part who is deeding their right, title, and interest to their estate. By deeding that in, that's a tax-exempt transfer for estate planning purposes. But once put in there, don't transfer it back, because that'll be a taxable transfer back to you. So that's the scenario. And so you need to know that right up front before you do. Now, the next document in the list of forms are bill of sales. And by the way, if you got more than one parcel of property, you know, you just use 2 grant deeds. You don't put it all on one. Sometimes people have property in this county and they got it in that county, or this state and that state. Well, fine. There you need to do more than one. And so, but follow through along that line. It's served very well. At least, you know, I've seen it work for more than 20 years. And that's kind of important. Then there's the bill of sale, which has to do with the automobiles, trucks, mobile homes, you know, boats, you name it, washing machines, so on and so forth. And you can do more than one bill of sale too, but basically you just duplicate the form in which you accomplish it. And that's all done before a notary, but also in the preparing of these forms. You cite in there who the instrument is prepared by. And so that's kind of new, you know, that, to make that disclosure. In my case, Western is the one that did the creating. Otherwise, I referred to it as Western LT. I've referred to it from time to time as my wife's estate. But also, trusts have a statute of perpetuities. The statute of perpetuities on these is 20 years, 9 months. Being that my wife has been gone for that length of time plus, it now is Western Foundation. See, once you get to the statute of perpetuities on trust, it then becomes a foundation. And you have seen or heard of the Ford Foundation, the Rockefeller Foundation, and so forth. After the creators died, 20 years and 9 months went by, then becomes a foundation. Some are registered as that and some are not. That's up to the parties. Okay? Now we got assignments here, and this is a terribly important document because you can assign bank accounts to the estate. You can assign life insurance policies to the estate, making the estate the beneficiary. So if something happens to you, the estate gets the check. That's kind of important, that there's not a breakdown there. But also, once this is done, you got to go to the company holding that policy and see to it that on their records they have changed beneficiaries. So there's 2 parts to that. It's the same way with the vehicles on the rolling stock. If you're going to continue to license and insure and that type of thing, you want to disclose the name change to the state if that's what you're going to stay with and in. All right? So this is important. Now, the next document, maybe I should go back to the assignment of bank accounts and so on and so forth. When you're going to create a bank account under the trust name, from what I've seen in the past, one should go to another bank to start a bank account from scratch in the trust name. Because invariably what will happen in the bank where your account is now, or the banks where your accounts are now, is that they'll tend to slide your taxpayer identification number right into the estate, which will actually, within the system, not allow the separation. And so it's terribly important that account is stepped in another bank, and of course you do that with a taxpayer identification number that you obtain from the trust, indeed, if you wish. Because I've seen it where they'll confuse the two. And also, if you're going to fill out an SS4 form, which is an IRS form for a taxpayer identification number, be sure you don't put your personal information on it, only the trust's information. Otherwise, IRS will have you clung together with Elmer's glue. And so you don't want that. Separate. The word, it is separate. And of course you never use words like, well, this is my trust. No, this is the company. Yeah, they do this stuff for theirs. I only help a little once in a while. Actually, Ralph Nader perfected this to the highest degree. I provide services to the foundation in exchange for credit. So, if I was out there busy and I lost my cap, the foundation buys one to replace it. That way it's deductible. I think you get the picture from that. If I go out to buy orange juice, cereal, milk, it's the foundation buys it. So I provide services in exchange for credit. Basically, I don't have 5 cents. That's mine. But I am entrusted to carry the trust billfold. And when a purchase needs to be made, it's made by the trust. This is the trust's money. And being that I'm acting in a co-trustee capacity, I must be sure that it's receipted. And the receipt goes right there. People have no idea how important receipts are to cover themselves, but also to cover the estate trust's revenues. Because basically in that structure, everything's deductible. And so you're walking in a whole different system. I mean, I was thinking about going out to a saloon last night to have one glass of beer. I don't drink enough beer to even talk about it. Probably 3 glasses this year so far, but I was thinking about accumulating the 4th. Well, you have to use this, and I get a receipt at the bar, because it's got to go in here. Every dollar of trust funds needs to be covered. So it's kind of easy. As far as organizing them go, they're always kept in Ziploc bags that cover a certain period of time so that one can search back and prove. Once I had an FBI agent do a false affidavit on me. Well, let's just put it this way. An assistant attorney general created the false affidavit, forged the FBI signature to it, and then notarized it. Well, when they walk into court, remember, they're right, and you're a peon with have very little say, and of course whatever you do say might not be respected by the bench. Well, guess what? I happened to have at that time was the trust receipts. And so that false affidavit didn't fly because I was in a completely different part of the country. Now, we'll go on just a little bit farther here. When I finish this up, I got a couple of cuties for you. So we got the assignment is not just preparing it, but also seeing to it that the beneficiaries are changed, including new bank accounts. And you can take the money from there and you can put it in this one over here. All right, declaration of homestead. As the head of the family, male or female, you have the right to transfer homestead rights to the estate. And there's a document in here for that, so that you can take advantage of protections of the law, plus reduced what they call taxes. And it makes quite a difference in some parts of the country whether it's homestead or not. And so I just wanted you to know that you don't give up your homestead rights because you've created your estate. For those of you that would have children under 18, you can appoint a general guardian, and that form is in here as well, so that those children are named. The parent or parents can execute it, and so there is a document wherein the party that you have selected, which would probably be a brother, a sister, or mother, father, whatever, can move in, assist the children, work in and with the assets of the estate if the ones are not old enough. I can remember my daughter at the age of 14 went to a car dealer to buy a car. And, you know, eventually the price was arrived at, and she and other members of the family were hustled back into the office to close and finish the deal. And the guy getting the paperwork done discovers she's not of age. And he says, "You're not old enough to buy a car." And she said, "How old does a trust have to be?" There was about a minute of absolute silence. Anyway, she just kept counting the money for the car. The sooner children can be taught business, the art of business, the art of managing, the better. I mean, the better. And this is an opportunity where they can help, where they can work with, and they can see, so that they are prepared when adversity hits. Now, the most important part of all we come to now, which is the last will and testament. You see, the object here is, before you pass on to the hereafter, everything should be transferred here. And as you go along, there may be other things that need to be transferred. But the reason for this will, and by the way, there's two types. There's one for the male and one for the female. There's a testator, which is for the male, and the paper sticking together here. And there's the testate rex, which is for the ladies. Basically, what does this will do? Legitimizes this whole stack here as the estate. That's why this is in here. And there's a couple of things it needs to do. Number one, you need to leave to the estate anything you failed to transfer to the estate while you were living. Gets transferred now. You know, we're out here in the sticks, you know, in North Dakota, but there gets to be co-op stock from the power company, from the telephone company. Not everybody's made the arrangements to transfer those to the estate. Well, so then if there's death, yeah, this can be transferred to the state by the surviving co-trustees. Also, in the final analysis, this is the document which discloses who's executing these documents, this business, this company. Yeah. But also, it exempts what a conventional will doesn't exempt: all last, just costs and fees. I've seen estates cleaned out with that. There is a benefit in this country of, I call them entitlements, but a lot of government agents don't call them that. Medical services is one of them, and your exit or your entry to medical treatment is through the emergency room, and they must post a placard on the wall. Regardless of your ability to pay, they must provide the treatment you need. Also, there's a death benefit in this country people don't know about. You know, the casket, the funeral process, and so on and so forth. Once the burial is all over and done with, they've got 90 days to collect. And if they don't collect within 90 days, they're unable to collect. And so they usually always collect at a reduced rate from the county. But at least you preserve something for those who come after you. It's nice at any time the estate could step in with a surviving co-trustee managing it and pick those up. And that's nice, provided it can afford to do so. But also, it isolates it from those so-called last costs. Same way with, you know, the homes that people get sent to and so forth. The job here is to protect the estate for the surviving heirs so that there's something there for them. Now, it's kind of important. It's kind of important. Now for a little more humor. One day I got a call from a judge from Texas, ordering me to come to Texas. Well, there's one thing I knew, at least at the time, that as a person who lived in North Dakota, that a Texas judge would not have jurisdiction to compel my appearance. But, you know, he possessed this Southern Texas gentleman behavior, and so I decided to oblige. And so I had to find somebody who had a piece that was going to go that way and had the money for the fuel to get there. And this was a Monday that I got this call. Had to be there that week, and I didn't get there until it was at 5:30 on Friday night. The courthouse was open, and the parties that were of interest in our appearance were there. The bottom line is that the court must have known something that nobody else knew, because a whole bunch of people needed to plan their estate. A presentation was put on. The judge was so cooperative that as the documents were being prepared, the judge had kept the courthouse open all weekend for the recording of documents. That was nice, you know. So at 9 o'clock on Sunday night, the immediate crisis, everything had been created, and there was 2 secretaries working, you know. Had been created for this family and the attached families to this family, or it would have destroyed a total of 6 farms. Well, nobody likes to see that happen, and so that was done. The next morning, the judge calls and invites, and it's the only time it's ever happened, I want to tell you, invited me for breakfast. At a filling station, I went over there, and he made this crashing statement. He said, "No, Ron, I don't want you to leave town." Well, I said, "Judge, you didn't have the jurisdiction to get me here, but now that I'm here, I don't expect I'll leave town until you say it's all right." And pointed us out to another facility to go sit there. And I'll tell you, he had 28 different families that needed to cover themselves or lose everything. And so, of course, that was done. Every effort was made. When you take a look at the documents that were filed at the courthouses on those efforts, which were grant deeds, you know, bills of sale, assignments, trust registration, that can all be done. You can either register or not register, but if you want to protect real estate, you need to register at least the grant deed. Anyway, out of all that shuffling of paperwork, the judge managed to do his own estate out of the forms and filings. And I met him a few years after that, and he said, "Ron, you know," he said, "I haven't told you about this, but he said, you know, I got sued." "Really, Judge?" "Yeah. I got sued twice." "Twice, Judge?" "Yeah." "Well, the first suit I won. So that was all right, you know." "Yeah." "Well, the second suit I lost." "Yeah." "Well, that was all right too, because I don't own nothing." So you know what a judgment's worth against you if you don't own anything? Not worth the paper it's written on. And that's why the rich and the powerful arrange their affairs, so that they get anything and everything they need, but that they're exempt. They're exempt from judgment. Oh, did they get judgments against them? Very likely so. In some cases. However, it means nothing if you have no assets to levy on and to seize. One of the toughest businesses in America today is independent owner-operators running up and down the road with those semis. That's a tough job to make the ends meet on that. There are companies that I'm aware of that operate as a trust, and they only hire trusts to run their trucks. That cuts down the overhead of the basic company quite a bit. It also cuts down the loss of wages of those trusts driving the trucks. It's terribly important that there be enough there left after you've worked your buns off to pay all the bills. And generally across the board, it increases the take-home by 35%. So planning is a lot better than not planning. Does that require management? Yeah, and in a different way. There's also other protections in this trust that wouldn't be readily noticeable. You've got your whole list of co-trustees up there. What if one of those co-trustees goes out and gets married, and there gets to be real problems within that marriage, and there gets to be a breakup, there's going to be at least enough information that passed to know that that son or that daughter may be a perceived heir someday. And, you know, being that they're listed co-trustees. Well, as long as you're alive, you can cancel any co-trustee. So you can adjust for circumstances beyond your control. That's what I'm saying. I've seen estates dragged down unbelievably out of just petty stuff. When attorneys get their paws and their nails into assets, they usually end up getting some of them. I'll tell you, in the handling of some of these estates with just wills, you can often see 50% of the estate disappearing when these deaths occur in the family and the attorneys get a hold of it. And so the job is to prevent that, so that you don't have any of that action. Does it take a lot of legal knowledge to do a good job? No, it doesn't. I have a friend that right in the middle of closure, during all of that hassle, there got to be 2 foreclosures, a bank and a farm credit system. Well, in the middle of that hassle, mother-in-law dies. Well, she managed to handle that. And then her husband goes out on a fishing trip one day and drowns. Well, she handled that. Then the IRS came after her. Well, she handled that. And then her mother died. And when she was hunting for her will, got to thinking that that will might be in the hands of an attorney, and she walked into the attorney and said, I want my mother's will. And he gave it to her. Because he figured she certainly knew how to handle that estate. Because the word gets around when you prevail, when you stand up and when you do. Was the workload there? No. The job was to get the organization not only organized, which she did. I can remember seeing her hand type each one of the forms. I remember seeing her do that. Well, I let her use mine. I let her use mine to copy from. She typed them out. She did the reporting. And she did the standing behind it. And as of 4 years ago, there's 0, they're out of debt completely. Now that's kind of nice. I'm going to tell you, you could bring an army and you couldn't convince her into going into debt again. There's no way. Not as long as she lives on this earth. Because of the dishonesty she saw and lived with the financial community. And so one has trouble. You can have debt in assets. The asset's not totally paid off, but you can transfer whatever right, title, and interest you have to the estate. And what happens is the state starts making the payments on the obligation. Now, I don't want you to confuse this estate entitlement with the other entitlements within the government itself. Because if you've got a financial difficulty on a farm, a business, or your home, you don't want to do this first before you go for an entitlement. You get in there and get the rewrite done there first. And after things settle down and gets in order, then you can plan your estate. But there are entitlements for individuals, not for trusts. Remember that. So if you're going to need those individual entitlements and the rewrites under those programs, so be it. But don't be messing together with an estate, because it's going to not allow it to happen. As long as you know that. You see, this is crucial decision you have to make up front, is whether you're going to do something or not do something. And so it's important that those big decisions are weighed before you step forward. And don't start if you're not going to follow through, because it only messes things up. A number of years ago, a lot of the debt for farmers in this country, we were having difficulty getting the government organizations to live up to the law. What's new, you know? But we have that problem. And so what farmers were doing at that time is they were creating their estate when there was no hope. You know, I keep picking up this stack of papers here to show you. And what they did is they had the trust, which didn't have any bad credit record at all, create a new note and mortgage and give it to a South Dakota trust. A South Dakota trust which didn't charge any fees, so that there would be a third party holding the note and the mortgage. And why? For the purpose of discharging the debt at the bank or at the farm credit system. And then of course they managed to liquefy it as well by the use of a private bank. But the right to bank exists, whether it's in your own person or whether it's in the estate. The right to bank is there. But these entitlement programs, you need your taxpayer identification number, shall I say, your social security number, to make those work. You hear me? And this was private lending owned by the trust that created the debt that was used to discharge debt. And there's a lot of that in existence right now. Because in 1977, the law changed. So you could pay a promise to pay with a promise to pay. And most people aren't aware of that. But all you needed was a trustee that would hold the promissory note. And why would this trustee out of the blue hold this promissory note? Because they didn't have to worry about you dying. If you died, they knew that this was going to live 20 years and 9 months after your death. So they didn't have to worry about any foreclosure down the pike because you're dead and not able to produce anymore. You see, the trust would be there, the trust would see to it. With the surviving management, that continuity was there, so you wouldn't have this tremendous disruption. I saw farmers lose farms because their mothers and fathers had not planned their estate. And by the time they got done paying the taxes on the transfer at death, that taxes on that estate through probate, by the time they got done paying that, they had so much debt on the property they could not generate enough money to ever pay those taxes off. Those estate taxes couldn't be paid without losing the farm. Well, that's just poor planning. But I saw it all over the country. So we need to plan a little bit. And I'm telling you, don't do this in any manner to scam. This is something that's legitimate for those who do plan to stay there and see to it that those that survive them are in charge and stay in charge, thus minimizing the risk, minimizing taxes, and so on. At any time, Once the trust is created, it can sell property. Many trusts have sold parcels of property, and so they've needed release from Trust 2 and Trust 3 if they liquefied it. And they got them. No fees involved. Ladies and gentlemen, watch out for this. You know, this when somebody's got their fingers out to get money out of your pocket, you might just well go another direction. Because that's what the game is. You don't want that. There's no intent here to put the fingers into your pocket. Alright? Now, there's also been a convenience here that's been done. There is a doctor from Houston that actually went and put all these forms on a DVD. So you can obtain all the forms already typed in, so that all you got to do is fill in the blanks, because the form's are already typed in. Or you can just get the forms, hear me? And type them on a machine yourself, type them on a computer. And to get these forms, as they are, plus I'll answer any questions if you call. Send me, number one, send me a self-stamped addressed envelope. And if you do that, with a little note in it saying, please send me a set of the trust forms, I will duplicate these and I will put a set in the mail to you immediately. Because one of the things is, if you're going to call me, I'll know if you got a question on any particular item. Instantly I can give it to you. And there's no fees there either. I can tell you this, that if you want this DVD, I think it's going to cost you $10 for these that are already typed on. Because this doctor did it, reproduces it, and put it somehow at no revenue above the cost. So he's got that. In this case here, I got a copying machine, it runs, and so I'll run it off and throw it in the mail. But self-addressed envelope, and as near as I can tell, it should be $1.39 on the self-addressed stamped envelope. If you could do that, please. I'll bear the cost of the copy, and I always have a few sets of copies around, so because there's some that go out every week. But then at least I'll know how to answer your questions. My telephone number is 701-674-3630. So I can be reached anywhere from 6 o'clock in the morning Central Standard Time to 11:45 each day, 7 days a week. Now, if I'm not home, I apologize. If you ring me any other time and I hear it, I'll answer the phone. But I do have to exist in a manner, and there's things I have to do, so I can't be on the phone 100% of the time. So that's why I've set that, and that seems to work. Also, with that telephone call, I will give you the number as to where you can get these already typed on a disc. Alright? So it may save you the $1.35 postage to just get it directly from the doctor that put them on. So he just sat there and typed them all on himself. So that's kind of nice that somebody would offer to help. So if there's any questions, I'd be happy to answer them. Ring me on the phone, and I'll address them to the best of my ability. I wish you the best. and lots of luck.